In the last chapter, you learned that MLS input is an extension of the listing agreement and that compliance is contract management in real time. Now we move into the next document that directly controls risk, negotiations, and contract enforceability in Arizona resale transactions. The residential seller's property disclosure statement and its advisory language. This is where contract writing becomes protection. When the SPDS is completed properly, it reduces surprises, reduces renegotiations, and reduces lawsuits. When it is sloppy, incomplete, or guessed at, it becomes a roadmap for disputes. Residential Seller Disclosure Advisory. Why this page matters. Before the SPDS even starts. Arizona law requires sellers to disclose material facts about the property even if nobody asks. That duty exists whether or not an SPDS is provided. The advisory makes this crystal clear because sellers sometimes believe, if we don't do the SPDS, we don't have to disclose. That is not true. The SPDS is a tool to help the seller comply with the law and prevent accidental non-disclosure. This matters in contract writing because disclosure is not a side task. Disclosure impacts whether the buyer can cancel, whether the seller is in breach, how inspections are negotiated, whether the appraisal survives underwriting, and whether the transaction closes on time. Phoenix Metro. Example: a seller in Tempe says, "We are not giving an SPDS because we don't want to be responsible." The reality is the opposite. Refusing the SPDS can increase risk because the legal duty to disclose still exists, and now it looks like the seller is avoiding transparency. The core rule: truthful, thorough, and never guess. The advisory emphasizes 3 seller behaviors that protect everyone in the transaction. Answer truthfully. Answer thoroughly. Attach documentation whenever possible. This is not about being nice. This is about preventing a later claim that the seller hid information. Receipts, permits, warranties, invoices, inspection reports, and leases help prove what the seller knew and what they disclosed. If the seller does not know an answer, the seller should not guess. Guessing creates false representations. A guessed answer can become misrepresentation even if the seller did not intend harm because the buyer may rely on it as fact. Mesa. Example: the seller guesses the roof is 10 years old because it sounds right. After closing, a buyer discovers the roof is 22 years old, and the insurer denies coverage without replacement. The buyer claims they relied on the seller's disclosure. That guess just became liability. Duty to disclose. When asked, and duty to update. When things change. The advisory warns that if a buyer asks about something, the seller must disclose the information, even if the seller does not think it is material. It also explains a second duty that many sellers miss. If something changes, or if a prior statement becomes misleading, the seller must disclose the update. This is critical during the listing timeline because properties do not freeze in place once listed. Phoenix example. While listed, a monsoon storm causes a new roof leak. Even if the leak is patched, the seller should update disclosures because the condition changed and the buyer's decision-making could be affected. Civil liability. Non-disclosure can equal fraud. The advisory states the legal reality plainly. Non-disclosure can be treated like fraud under certain circumstances. In real estate disputes, the argument is often not "you lied." It is, "you failed to disclose what you knew." If the fact is material, silence can be legally damaging. This is why the SPDS becomes part of risk management and why agents must treat it as a contract writing priority. Warranties that survive closing. What that means in real life. The advisory notes that these disclosures are warranties that survive closing. That concept is huge. Many sellers think once the deed records, everything ends. But disclosure disputes often begin after closing when the buyer discovers a defect. Surviving warranties mean the disclosure statements can continue to matter after the transaction ends, which is why accuracy and documentation are essential. Contract connection. The AAR resale contract timing rule. The advisory ties directly to contract writing by stating that when using the AAR residential resale real estate purchase contract, the seller is required to deliver a completed SPDS within 3 days after contract acceptance. If the seller does not provide it as required, the seller may be in breach, and the buyer may be able to cancel and recover earnest money. This is a perfect example of integration. Disclosure is not just law, it is a contractual deadline with a real remedy. Gilbert example. A buyer accepts a contract on a home in Power Ranch. The seller delays the SPDS because they are busy. The buyer uses the contract remedy to cancel within the proper window and gets earnest money back. The seller then relists and loses momentum and value. That loss was preventable with timely disclosure delivery. What sellers are not required to disclose. Under ARS, paragraph 32, 2156, and the trap that still exists. Arizona law states sellers and brokers are not obligated to disclose certain stigmatizing events, such as a natural death, suicide, homicide, felony crime, HIV or AIDS status, or proximity to a sex offender. This is commonly called a non-disclosure protection for stigmatized property factors. However, the advisory also includes the trapdoor. The law does not protect intentional misrepresentation. If asked directly, the seller cannot lie. The seller should either answer truthfully or state that they are not legally required to answer. Scottsdale. Example: a buyer asks, "Has anyone died here?" The seller knows the answer is yes. The seller should not say no. The legally safe approach is either truthful disclosure or a statement that the seller is not required to answer. SPDS page 1. Contract writing impacts before you even reach roof questions. The first section is property and ownership. Students often underestimate this part, but it impacts contract drafting immediately because it identifies legal ownership, occupancy, rental conditions, HOA status, liens, assessments, easements, and title issues. Those items affect title review, buyer financing, appraisal conditions, and closing timelines. Legal owner and date acquired why it matters. This helps confirm who has authority to sell and who must sign. If ownership is an estate, trust, or multiple owners, contract signature authority must match title. If the seller cannot convey marketable title, the contract can fail. Phoenix example. Property is held in a trust, but the seller signs personally without trustee authority. The buyer later learns the trustee must sign and closing is delayed. That is a preventable contract drafting issue if ownership is verified early. Unincorporated area and affidavit of disclosure. The county rule that trips up. Rural edges of metro. If the property is in an unincorporated area of the county and qualifies under the parcel transfer rule, the seller must provide an affidavit of disclosure. This frequently shows up in Far East Mesa, parts of Queen Creek, or county islands. This is not optional. If required, it becomes a contract compliance deadline similar to the SPDS itself. Rental and lease. Questions: where contract writing changes immediately. If the property is rental or leased, the contract must reflect tenant rights, lease terms, deposits, and occupancy timing. The SPDS prompts disclosure of lease copies, deposits, and lease expiration. That information influences the buyer's possession date, investor underwriting, and the buyer's cancellation risk. Mesa. Example: seller says, tenant leaves at closing. Lease actually runs for 6 more months. If the buyer is owner-occupant, the contract may collapse because possession cannot be delivered as expected. This is why SPDS rental questions are contract critical. FIRPTA question. The tax issue that becomes a closing issue. If the seller is a foreign person, withholding may apply. Agents do not give tax advice, but contract writers must recognize this early because it affects escrow preparation, net proceeds, and timelines. Age-restricted and historic district questions. Special regulation triggers. Age restriction can affect buyer eligibility and occupancy rules. Historic district designation can affect remodel permits and buyer expectations. Even if this is not a contract clause in every case, it becomes a negotiation issue and a disclosure issue. Association HOA disputes, fees and violations. The litigation hot zone. This section asks about mandatory or voluntary associations, fees, unresolved violations, disputes, and litigation. These answers can directly affect buyer cancellation rights under HOA document review periods and can affect lender approval if litigation is significant. Chandler. Example: the HOA has pending litigation over construction defects. Some lenders may restrict financing. If that is disclosed late, you will lose the buyer late. If disclosed early, you attract the right buyer and avoid collapse. Liens assessments, title issues and access problems, why they belong in early contract strategy. Liens and title issues affect the ability to close. Easements, encroachments, lot line disputes, access problems, private road maintenance agreements, and notice of violations can all create major contract friction. Contract writers must connect these disclosures to the purchase contract terms, title contingency, and cure periods. Phoenix example: a property has an unrecorded easement and a shared driveway agreement that is not documented. A buyer's lender requires evidence. Closing delays. If you identify it early, you can coordinate documentation before the buyer's deadline. SPDS page 2 and 3. Building and safety. Roof structural wood infestation. The negotiation engine. The building and safety section becomes the foundation of inspection strategy. The roof questions require the seller to disclose leaks, repairs, warranties, and transferability. This directly impacts buyer inspection decisions and may influence whether the buyer requests a roof certification or seeks concessions. The foundation and settling questions matter in many Phoenix metro areas due to expansive soils and settlement patterns. These disclosures influence structural inspections and risk tolerance. The wood infestation notice tells buyers to verify termite history through the Office of Pest Management and prompts sellers to disclose past presence, current presence, damage, treatment, warranties, and transferability. Termite history is one of the most litigated issues in Arizona resale property. Buyers rely on seller disclosures heavily. Phoenix example: a seller discloses past treatment, but provides no warranty or report. The buyer orders a WDI inspection, finds evidence, and negotiates repairs. If the seller had documentation attached, negotiations would be cleaner and faster. Course discussions with answers. Discussion question: why does Arizona emphasize "do not guess" on disclosure forms? Answer: because guessed answers become representations that a buyer may rely upon, and incorrect representations can create liability for misrepresentation or non-disclosure. Discussion. Question: if a seller and buyer agree that no SPDS will be provided, does the seller's legal duty to disclose material facts disappear? Answer: no. The legal duty to disclose material facts remains even without an SPDS. The SPDS is a tool to help satisfy that duty. Discussion. Question: why is the SPDS delivery deadline a contract writing issue, not just a disclosure issue? Answer: because the purchase contract requires delivery within a specific time frame after acceptance, and failure can create breach and cancellation rights.